Hello, I'm Kris. I'm a partner at Analysis Group. I'm an economic consultant and have provided both consulting and expert support for plaintiffs and defendants across a variety of commercial litigation matters. And increasingly over the past few years, my work has involved mass arbitrations, which is our topic for today. I'll ask our panelists to introduce themselves, and then we'll dive right in.
Hi, everybody. I'm Jonathan Waisnor. I'm a partner at Labaton, Keller, Sucharow in New York, and I lead the firm's mass arbitration practice, which we introduced in 2020.
Michael McTigue, Skadden, Arps, New York, primarily a class action defense lawyer, but more recently been defending mass arbitrations in the United States.
Hello, Amy Turk. I'm a partner with McGuireWoods in the Norfolk, Virginia office. Primarily a class action defense lawyer, but like Mike, since 2018 have increasingly over time been doing a lot more mass arbitration and the interplay between the two.
And if you were here at the panel right before lunch, that panel, I want to say thank you for queuing up nicely this topic of arbitrations. But similar to the panel yesterday on mass torts, we're going to start with the basics. Mass arbitration is a, I would say, relatively new mass action business model that's become prevalent in the United States. And as it sounds, it's a model in which plaintiff firms submit dozens, hundreds, or thousands of individual but identical demands for arbitration on behalf of individual consumers. I'm going to start with just a few data points on the scale of mass arbitrations in the United States. So during 2024 and the first half of 2025, there were more than 500 plaintiff law firms that filed consumer mass arbitration demands with the primary arbitration venues in the United States. And these demands were filed on behalf of hundreds of thousands of individual consumers against hundreds of unique companies. Most companies face demands from multiple plaintiff firms and across even multiple topics. And again, we're going to get into the details of all of this today, but even those that are filed, those demands that were filed that are part of public data sets, that's just the tip of the proverbial iceberg. Much of the activity around mass arbitrations happens even before demands get filed, and we're going to talk about that today. So we'll discuss briefly the evolution of mass arbitrations in the United States and the current processes and strategies by which arbitrations are originated by plaintiff firms. And we'll talk about the strategies employed by defense counsel when they're facing these demands. And we'll go behind the curtain, so to speak, to talk about the resolution of mass arbitrations with discussion of why those same public data show that of the arbitration demands that are filed with an arbitration venue, less than 1% of them are actually decided on the merits with an award to consumers. So without further ado, I'm going to start off with the basic question. And again, I'm going to ask everybody on the panel because I do think that the plaintiff's bar and the defense bar might have different answers to this question. But what is the mass arbitration model? Let's start with square one. Maybe Mike, could you set the table for the audience with this one?
Yeah, let me just back up a bit. Does anybody here, do people here know what mass arbitration is? People familiar with mass arbitration? Okay, so mass arbitration, it's a unique creature in the U.S. because of that consumer arbitration and employment arbitration agreements are enforceable in the United States. For several years, there were cases out of different jurisdictions throughout the United States that say you couldn't have a consumer or employment arbitration agreement with a class action waiver. There are states like California, Delaware, and some other states that had held that such agreements were unenforceable, they were unconscionable because they waived a consumer's right to bring a class action. In 2011, the United States Supreme Court had a decision, Concepcion versus AT&T, in which it held that under the Federal Arbitration Act, an act that's been in place for 100 years in the United States, state laws that inhibited the ability of companies to contract with consumers or employees to require individual arbitration were unenforceable. And therefore, you could have arbitration agreements with consumers and employees that had class action waivers and have individual arbitration proceedings. And that was a great victory for AT&T at the time and for businesses. And after that, you saw a proliferation of individual arbitration agreements across industries in both the consumer and employment context. There have been several attempts by state courts to chip away at this, but the Supreme Court over and over has upheld this principle of ensuring that individual arbitration agreements with class action waivers are enforceable. Immediately after this decision, there was an early attempt at mass arbitration that I was involved with, where a plaintiff's firm tried to break a company and said, I'm going to test this and see if this company is willing to go forward if there were several arbitrations proceeding at once. At the time, there maybe have been, I think there were only 50 arbitrations that had been launched. I was part of that defense group. In one of the early arbitrations that proceeded, I was there, and what happened was the individual, the lawyers on the other side appeared, we appeared, we asked the question, is the plaintiff going to show up? Is the plaintiff available to participate? Yes, the plaintiff's available. When's the last time you spoke with the plaintiff? I spoke with the plaintiff, a couple of days ago. We then dropped on the table with the arbitrator the death certificate, indicating that the individual had unfortunately died a year prior to the arbitration hearing. At which point the other side took a break and did not come back. All of the rest of the arbitrations were dropped at that point, and so that early testing did not work. What's happened more recently is that there was a lawyer that was chief appellate counsel at the United States Chamber of Commerce, actually helping companies defend arbitration agreements. That lawyer left and started the latest iteration of mass arbitration. What that lawyer realized was, if I could gather a critical mass of individuals, whether employees or consumers, and launch them all at the same time, the fee pressures that are on the companies would be so enormous that we could get a resolution relatively quickly. And why that's important is because under our biggest arbitration provider rules, that is JAMS and AAA, the business has to pay the vast majority of the fees associated with arbitrations. The consumer or employee only has to pay a very small initial filing fee. And so let's say the total fees paid to the arbitration body or the arbitrator are in excess of $10,000, $20,000. The consumer would only have to pay, or the employee have to pay, $200 or $250. And so the thought was, with all of these fees that the business is going to incur, if I can launch a campaign with 10,000, 20,000 individuals all at once, the business would be encouraged to resolve this early, regardless of the merits. And why has it worked, and why has it worked today? Well, there is an ability of consumer lawyers, plaintiffs' lawyers, to ramp up very quickly, gather claimants very quickly because of social media, class action settlement lists. Their ability to gather folks economically and quickly is very different from the time period right after Concepcion came into existence. So that is our view of what happened and where the world is. We, on the defense side, have some call this extortion because of the nature of these proceedings and the fact that, we've had situations where lawyers on the other side said, I have a gun to your head. You were going to owe these fees immediately, so let's get them resolved. I'm not saying all of the plaintiffs' lawyers have used such language, but we have heard that on the defense side. So from our perspective, that's setting the table for how we see things are today.
I'm going to follow that up by asking Jonathan to describe what is the mass arbitration model. Same question.
Yeah, sure. So I think really it's just a lot of individual arbitrations with some common theme, whether it's a legal issue or some individual fact that's probably common among claimants. And it would be, if you look at a Venn diagram of mass arbitrations and things that would have been class actions but for arbitration clauses, you'll get certain overlap, but it's not going to be 100%. And that's because in the US, mass litigation is also very common. So especially in cases where individualized issues tend to predominate, or there may be a lot of states with state laws that apply, you have mass litigation in court. The real difference is in mass arbitration, there's an arbitration clause, and those claims get filed in arbitration. And what our Supreme Court has held is that under principles of arbitration, a class action waiver, which is usually included along with the arbitration clause, usually would defeat any rules at the arbitral provider to do class-wide arbitration. And so, what you have is you have to file these individually. You usually file them within the statute of limitations, so there's a time period by which you do that. And there's an open issue as to whether the arbitral body can consolidate the arbitrations into a single proceeding. But typically, the class action waiver clauses also include a bar to consolidation. And so that's why you see these being filed as individual demands. And I think from the plaintiff's perspective, what you're doing is you're just following the contract and the rules of the arbitral body to pursue the claims in the forum that the parties agreed to pursue them in. In terms of sort of where it came from in the plaintiff's bar, I think Mike referred to one of the early pioneers of mass arbitration. And I think what you've seen in the space is that the folks who have gotten into mass arbitrations and developed mass arbitration practices are not necessarily the traditional class action firms. There are entrants into the space that you haven't seen as lead counsel in class actions, or necessarily even folks who had a very public presence. And so I think that's one feature of mass arbitration is that there's a specialist bar in the United States that is growing and as you said, is expanding.
Very good. I'm going to ask the same question to Amy, if there's anything you want to add to what Mike or Jonathan had to say.
I feel like Mike and I are kind of beating up on Jonathan 2 against 1 here, but I think I have a unique perspective, not just being a mass arbitration defense, outside counsel defense specialist now. I also was in-house for 12 years. I was the client, and I was the one responsible at the time for my company to roll out the arbitration program in the employment context. And I remember back in 2018 when my first client got their first demand, and it was like, you get it, and I think it was, a letter demanding with a spreadsheet of, tens of thousands of people on it, and they were like, what in the hell is this? Like, literally, what is this? Because they had no idea what it was. And as I started studying it, I was like, thinking about my client, and if I was in this position, because I rolled out the arbitration program, and I was like, they're going to have to explain to their bosses why they're going to have to stroke a check for $8.7 million just to get the game going. And was this what was intended when the arbitration agreements were implemented? And, at the time, in fairness, I was like, this is a pretty genius, move in response to, the class action waiver issue that Mike discussed. And then as I got into the litigation piece of defending mass arbitrations and giving, I think, what I saw the plaintiffs bar their kudos in the strategy, I started to see things that really troubled me and my clients, which was where are some of these plaintiffs? Do they have control of these plaintiffs? Are these people alive? Were they customers? Were they employees subject to that? And so for me, and what we see in the defense bar, and what I think is the yin and the yang between the plaintiff's bar and the defense bar in the U.S. when we're doing this is, are these people truly your clients? Because again, the difference between class, where you have a named plaintiff who's a representative and of the entire putative class, and then it gets certified by a judge, and then you send notice out and all of those things. In a way, in the mass arb space, I kind of view the solicitation mechanism to be the notice that goes out that is somewhat unchecked. So since you're in arbitration and there's no judge involved, almost the defense bar, the defense attorney, becomes sort of the gatekeeper of the legitimacy of some of these claims. And it is really interesting how it plays out. And I know Mike used the word extortion, and no disrespect to them, but I've seen abuse, or I feel like there's been abuse in certain cases with certain firms, And that's where the fight always kind of begins. But that being said, I also think there's value into if you don't have to have the fight and you can figure out a way to get redress for the people that are actually exist and do something, an early case assessment, and figure it out early so that the people who have legitimate claims our clients can address it with, and the people that don't have legitimate claims, we have to figure out what to do with them. I think that behooves everyone because it's very difficult for a client who rolled out an arbitration program just to go to their CEO, or especially if they're publicly traded, and say, hey, stroke that $10 million check just to get the game going.
So let's dig into that. Maybe Jonathan, from your perspective, can you share some insights on how your team identifies a company for the purposes of bringing a mass arbitration? So for example, do you actually look at the arbitration clauses and consider what's in the arbitration clause? Are you looking for certain types of claims, certain types of companies? Okay, that was a multi-part question. So maybe what I'll just say simply is what makes a good candidate for mass arbitration from the plaintiff perspective?
Yeah, I mean, I think it's, it always starts with, what's the claim? Typically in the U.S., there continue to be a large volume of class actions filed, some of them where there are no arbitration clauses, so you see development in the law. Mass arbitrations typically, in the consumer space, tend to fall into three categories, I would say, which track the state and federal law in the U.S. There's a significant number of data privacy and data breach mass arbitrations. Data breaches are public. Data privacy issues arise a lot. There's a lot of litigation about them, especially in California. And some of you in the U.S. may, obviously know this, but for folks outside the U.S., we have what I like to call an alphabet soup of state and federal laws that govern data privacy, and some of those laws include liquidated damages provisions. So if the plaintiff proves a claim, they can receive $1,000, $750, $5,000 as liquidated damages. You also see these pretty frequently in the financial services context. So banks were some of the earliest adopters of arbitration programs. And there is an alphabet soup of federal laws, the Truth in Lending Act, the Electronic Funds Transfer Act, the Fair Credit Reporting Act, that, similarly have a lot of statutory provisions, a lot of compliance issues there, and you have a very active plaintiff's bar in those. But really in that area, I think what you tend to see is less mass arbitrations against the traditional banks and more against fintech companies. So there are a lot of fintech companies in the US. They very aggressively market new products to people, especially lower income consumers. They tend to take very aggressive compliance positions. And there is a lot of regulatory activity that if you're at the plaintiff's bar, you're definitely watching what the regulators are doing to see if there is private litigation. And then there are, what we like to call little FTC laws, so unfair practices, deceptive practices statutes in almost every state has one of these statutes, and they cover a very, very broad range of conduct. And again, as a claimant's lawyer, a plaintiff's lawyer, you're looking at not only the development of the private law, but also what the public regulators are doing, especially, when there is certain administrations, what are the federal regulators doing? And when the administration changes, maybe what are the state regulators doing to pick up the slack? And then there's also, sort of an expanding network of partnerships where you have, plaintiff law firms that maybe they have a client or they have a few clients, but they don't, there's an arbitration clause, and they, will come to another firm and say, hey, we'd like to partner or do a mass arbitration as co-counsel because you have the experience, you have the resources, and you have the expertise to understand this practice space. So I'd say they fit into those three categories. And as to your question about the arbitration agreement, of course, nobody wants to waste a bunch of time litigating a motion to compel arbitration by a defendant that is not likely to be successful. That doesn't help anyone. It's not a good service to the client. The courts are probably sick of it at this point. And so, you of course look at the arbitration clause to make sure you're understanding exactly, where the case is going to be, what issues are determined by the arbitrator, whether the claim is within the scope of the arbitration clause is very important. And I can say there have been some very aggressive moves in recent years, especially by defendant companies that are not even sort of signatories to the arbitration agreement, to go into court, and if there's a class action where they're a defendant, they may try to enforce another company's arbitration agreement against the plaintiff by saying that they're a third-party beneficiary, there's some sort of equitable estoppel. And those situations, I think you're going to see in the coming years are very interesting from a mass arbitration perspective, because it's an expansion of the realm of arbitration clauses into disputes that are not necessarily envisioned by a consumer who might know they signed an arbitration clause, but don't exactly know what types of disputes are covered and how broad that clause may sweep.
So maybe a follow-up question then, since Amy queued it up really nicely. Once you've identified a good candidate by doing this diligence, how do you contact the company? What's the first step in that process? Is it the demand letter? Is it filing the claims? Can you just walk us through kind of that part of the process of initiating and contacting the company?
Yeah, I think the most of the arbitration clauses include a 30 or 60-day notice provision. So, in initiating a dispute, you usually kind of need to go to the company in the beginning and say, hey, I've been retained by these individuals. They've asked me to resolve this dispute with you. I'm giving you notice of the claim, and let's see if we can enter into informal negotiation and resolution discussions. Sometimes, occasionally, I'll get outreach from company counsel before a mass arbitration or before I've even sent that letter, saying, hey, I've seen something on your arbitration platform, or there may be a case out there that I know there's going to be mass arbitrations, can we talk? And then typically, and I think what's really interesting about the data that you have, which is frankly far more mass arbitrations than I knew were even out there based on what my firm does, is that there are many, many more mass arbitrations that never make it to the filing stage of an arbitration provider because they are resolved through direct negotiations with the company. And typically, we'll negotiate a tolling agreement with the company, which has now, in the last several years at least, morphed into something more like a standstill alternative to arbitration agreement, where there will be a period of information exchange. A third-party mediator will be engaged, usually to mediate the claims. There will be a demand exchanged, and there will be an attempt to compare, notes both on the claimants and on the legal and factual issues underpinning the claim to see if there can't be a resolution.
Can I add something to that?
Yes, please.
And this was not Jonathan. I've never seen him do this, but there are certain plaintiffs' firms out there, copycat firms, what I would say, as far as they're getting creative. It's not just sending a demand letter, if we know each other, giving us a call and telling what's coming. I've actually had clients where they send, I guess it's the dramatic effect, where they send 50,000 demands to the CEO's house. I had that once. To get their attention. We've had them on loading docks, sent to loading docks to the company headquarters, masses of paper just regenerated of kind of copy demands that are almost identical except for the name, and address of the claimants. And so, it definitely, we see more creative ways of letting a client know in the mass arbitration space than we ever saw in the class space.
Mike.
So what's frustrating to companies is the way that these claims are gathered and then sent to the company. And let me give you a little bit of additional background. So as I mentioned, what makes this possible, I think, is modern technology and social media campaigns. And folks can see, they can get targeted advertisements. And these targeted advertisements will say something like, are you a customer of X company? If you are, you may be entitled to, let's say, $5,000, a statutory damages provision that Jonathan was talking about, maybe in a particular statute. All you need to do is take 2 to 3 minutes to fill out this form, and you're all set. We look at these solicitations, these advertisements, and it's unclear just looking at it what these people think they're signing up for. They could be thinking they're signing up for a class action settlement. Do they actually know they're signing up to be named claimants in an arbitration proceeding? We think some do not. We also think that there isn't sufficient vetting by some of these plaintiffs' lawyers in connection with gathering these claimants. What do I mean by that? Well, typically we'll get a list of these claimants when our clients share them with us or we engage in early discussions with opposing counsel. And we'll see massive amounts of deficiencies. The client will tell us that 50% aren't customers. I have no connection with these individuals. Then we actually dig into the facts, the underlying claims. Another 25% don't have claims under the theory of liability. So there wasn't, in defense view, adequate vetting. Under the professional rules of responsibility in the United States, when you bring a claim, a lawyer has to vet the claim before they bring a claim against a company, whether filing in arbitration or in court. And we think there are many issues associated with mass arbitration where some of these firms, and you hear this now, firms that aren't traditionally class action lawyers or necessarily know what their obligations are engaged in this practice, and we think that it raises fundamental consumer protection issues. And unfortunately, to date, these issues have not been addressed by anyone, whether they're regulators in the United States or courts, because private arbitration, there isn't really oversight. If you're in private arbitration, you have an individual arbitrator you can take it to, but where can you get redress if you're a company and you think that this is an improper tactic? I'm not saying all of the plaintiffs' lawyers in this space behave unethically, but we have seen over and over that a lot of them that are trying to dive into the space to try to make quick money are probably not doing it the right way under the ethical rules. And that's a concern that our clients have when they see some of these campaigns against them.
And I think taking it one step, and I'd be interested in Jonathan, what he sees from what I would call the copycat firms of people of his, from people of his ilk. Now there's a lot of these firms getting into the space that aren't even owned by lawyers, right? And how do you and your firm deal with kind of the new wave of plaintiffs' counsel that are coming in and trying to, expand on the business model that you've created? Because it's creating problems for you, I'm sure.
See, that's one of the interesting things is that, look, in court litigation and even in mass litigation in court, courts will bring the plaintiffs' firms together and say, work out a leadership structure, or tell me who you want to lead the case, and I will make that decision. In mass arbitration, there is the arbitration providers, JAMS, AAA, and even NAM have been pretty consistent in my experience in saying, if there are multiple firms representing different groups of claimants, they may each go into their own mass arbitration process, and there won't be any coordination or consolidation because the arbitration clauses themselves prohibit the consolidation. So you will have, in some cases, 10, 15 different mass arbitrations, each with a different claimant's law firm. And so the ability of the plaintiff, I don't think there is really an ability of the plaintiff's bar to self-police that. Where I think you have seen a little bit of process put in is the major arbitration providers, the AAA, the JAMS, the NAM. They've all introduced something called the process arbitrator. And so what that is there's sort of I think a rather small initiation fee paid by both the plaintiff and the respondent company. I think it's for AAA, it's like $3,000 for the claimants. For the company, it's like $8,000, regardless of the number of claimants in the mass arbitration. And there's sort of an arbitrator appointed, and the arbitrator is then dealing with a lot of the issues that Mike talks about, like was there sufficient notice? Were the claims filed with sufficient detail? Which arbitration terms apply? So in the last I think that was AAA's sort of introduction maybe 3 or 4 years ago with those rules. And so what you have seen, I think, is a lot more filings in AAA and NAM and JAMS, and a lot of navigation of some of the more, process-based issues in front of a process arbitrator before you get to the merits, before you pay the individual filing fees due from both the claimants and the defendants. But I think it's certainly a situation where I am not fully aware of what other plaintiffs' firms are doing. I do know there are some ABS firms out there that have spun up, but it is something that I know causes great concern among the defense firms. And I've had defense lawyers come to me and say, "Well, what are you going to do about this?" And the response is, "I don't know." Like, I mean, what am I supposed to do? Do you really want the plaintiffs' firms all talking to each other? Do you really want them all comparing notes on, what you're saying? Is that something that the clients really want or the companies really want?
I would just add to that, both the proliferation of firms kind of engaging in this on similar issues and the ease of sign up for consumers. We often see what we would call a cross-firm duplicate, where we have the same consumer signing up with 8 or 10 different firms because they've clicked on that box saying, would you like $5,000? And so there's no way for you to know if that consumer has done that 10 times with 10 different firms on the same issue, at least not ex ante. There's no way for you to know that either. And so it's compounded by kind of some of the mechanisms by which consumers are solicited for these mass arbitrations as well.
And I think that's an interesting parallel to mass torts too. So, you see a lot of the same criticisms of solicitation practices, and for those in the audience who are from the UK, this idea of book building, of maybe more familiar to you because of the litigation landscape in the UK, is a relatively new phenomenon in the US, because for many years we had the opt-out class action device, and there was no real need to go out to people, but state bars and the Supreme Court have held that lawyers can advertise subject to state ethical requirements, and so plaintiffs' firms have sometimes developed the ability to kind of do this. And I think one thing you've seen now with the AAA and JAMS and the process arbitration stage, similar to what courts do in mass tort situations where there are dual reps, is they will order some sort of process to identify the dual reps, have those issues sort of resolved by the law firms, and then they're kind of taken off the table at the outset of the case before you get into the litigation. And you saw a little bit of that in the 3M mass tort, where there were dual rep protocols. You may not see it as much because the arbitrations aren't public, but that's how the AAA, the JAMS, and NAM have been handling that situation.
I want to switch gears a little bit, if that's okay with you guys, because I do think, and this came up earlier, Mike, in your comments, mass arbitrations are sometimes described as unintended consequences of poorly written arbitration clauses. And so maybe I'll ask you to follow up on that, Mike, and what do you think makes a mass arbitration clause vulnerable to mass arbitrations, and are there ways companies have tried to mitigate the risk of mass arbitration in the way that they've constructed those clauses?
So, when the United States Supreme Court ruled in 2011 that an arbitration agreement with a class action waiver was enforceable, and there couldn't be state laws that prohibited that enforcement, most of the arbitration agreements that came into effect were extremely consumer friendly. And that is, the business said, we're going to pay all of the fees associated with it. Sometimes you'd see clauses in there that said, if you win in arbitration, you get a premium, or you'll get, whether for yourself, or you'll get an attorney premium, fee premium in connection with this, even if there's not a statute in the United States that provides for attorney's fees in connection with the claim. And so mass arbitration has caused businesses to revisit their terms, look at their terms, and put in provisions that attempt to address mass arbitration and the fee leverage associated with mass arbitration, and frankly, also the claims that are asserted that aren't legitimate. So they build in, as Jonathan said, a lot of them now have built-in procedures ahead of time, pre-arbitration dispute resolution provisions, either 30 to 60 days, where there's a period of time you can take a look at this inventory, have a discussion, and make sure these are real. There are requirements like the consumer has to personally sign the demand, the consumer has to provide details about the claim, why they think they're injured, what damages specifically they're seeking. This is all designed to prevent just one big demand on behalf of 10,000 people with vague allegations. So these provisions that have been put into place, they range between, we've seen some companies that have bars on mass arbitration. Not sure that would ultimately be enforceable for a variety of reasons I won't get into. Others have provisions that call for bellwethering or staging of arbitration proceedings. maybe into perpetuity, or some have opt-outs after a couple of rounds and mediations, so that parties can test the theory of liability, see what 10, 20, 50 arbitrations look like, so each side has some experience with the claims, which may give them some data points for purposes of a resolution. Others, a lot of companies now have batching. So we hear traditionally there's a ban on consolidation of arbitrations, individual arbitrations. In the context of a mass arbitration, we see provisions where if there's a mass arbitration, you'll batch them in 50 or 100. One arbitrator will hear 100 arbitrations and issue awards in that arbitration, again, for efficiency to keep the cost down for folks. We've seen court decisions all over the map on this. Many courts have upheld certain provisions. Other courts have said some of these provisions go too far. They're unconscionable. It will take too long for consumers or employees to have their case heard. And so they won't have an effective vehicle to vindicate their rights. That's the theory behind some of these court cases that say they're unenforceable. This is where I think a lot of the court battles are going to be over these types of terms. And eventually we're going to see some case up to the United States Supreme Court. I don't think anything's teed up yet, but we'll see some case up to the United States Supreme Court where on some of these provisions that businesses are trying to put into effect.
Jonathan, can you follow up and just talk about, kind of from the plaintiff's bar perspective, kind of how's the plaintiff's bar reacting to companies attempting to make these changes?
Yeah, and these changes have gotten, these arbitration clauses, which were complicated before for people to understand, for regular consumers, employees to understand, have gotten increasingly Byzantine and extremely complicated. And they're changing extremely, extremely fast because companies are using their power to push out changes to their terms of service as quickly as they can in response to an event or even preceding an event that they know may give rise to litigation. And I think you have seen a lot of battles about these new arbitration provisions, specifically about what Mike was talking about the staging and the batching. And there have been some decisions on, kind of on both ends. I think there was a very, very talked about case at the Ninth Circuit last year, the Heckman v. Live Nation case, where a company had a very enforceable, simple arbitration clause that called for jams administration. They got that enforced in an antitrust case. And then they came back and they changed it to a provider that there was some indication was they had sort of spun up in reaction to the expected mass arbitration. The rules were very complicated. They seemed to be written very fast. There was no appeal right for the plaintiff, but there was an appeal right for the defendant. All sorts of provisions that were sort of tailored to combat the incoming mass arbitration. And the United Circuit took that case and they upheld the district court finding that it was procedurally and substantively unconscionable. And the Supreme Court just rejected the cert petition. On the other hand, there have been cases saying, one batch of bellwethers is okay, two batches of bellwethers are okay, subject to the rest of the agreement and whether there are other provisions that might render it unenforceable. And so I think we're just going to see somewhere in the middle. I think a really interesting decision came down last year from Stars v. Jones, and that was a Ninth Circuit case where a plaintiff's firm had filed, I think, 70,000 arbitrations and jams, and there was no consolidation language in the agreement. There was no anti-consolidation waiver as opposed to class waiver, and so jams applied its base consolidation rules, put all the arbitrations together. The plaintiff's firm then went to court and said, well, this isn't okay because, under Concepcion and everything, you have individual arbitration. And the Ninth Circuit said, hey, hold on. The arbitration provision doesn't say anything about no consolidation. All it says is no class. Class is different than a mass or consolidation. And jams was applying its base rules. And what you haven't seen, I've been following arbitration clauses, and what I really haven't seen in the wake of Stars v. Jones is companies removing the consolidation waiver from their arbitration provisions and their class action waivers and kind of permitting the arbitration provider to determine the extent to which the claim should be consolidated. But I think that was certainly a win for the defense bar on this issue. And so I think it's going to end somewhere in the middle. And I think courts are using a lot of common sense when they look at these provisions. and looking at, okay, is this a provision that is going to have people waiting, in one case, for example, 156 years to have their claims heard? Or is this something that is a provision that is really trying to get the parties to the merits and eventually to a resolution of the dispute, whether that's in court or a mediation or something like that?
I want to spend our remaining 5 minutes or so talking about mediation, because I think that's where most of these end up. And Amy, I'll start with you, just because I know you've seen it from multiple different perspectives. Do you find mediation worthwhile in the context of mass arbitrations? Would you advise your clients to go that route? When in the process, and why or why not?
It's interesting. Mass arbitration, because I do a lot of classwork too, is I increasingly find myself having to actually hold my clients back and convince them that mediation doesn't equal agreeing to mediation early in a mass arb doesn't equate to weakness, because I think there's this knee-jerk reaction with our clients that are like, oh, they want to come at us? Okay, we're going to come at us. We're coming back at them, and let's go, And I have to say to them, okay, let's take a breath. Let's think this through. I have kids to put through college. I'm happy if you want to pay me a couple $1 million to go all the way. But once you stroke that check, and the plaintiffs' firms have to know this too, once a company strokes that check for all those filing fees, it is go time, and it is a long haul for both sides. And is there merit to seeing what we can do before that nuclear option is taken? And I have all these difficult conversations, and each client's different, right? So, but my number one thing is, it doesn't hurt to talk early. When you set it up in a mass arbitration, because you really do need individualized data, because these are individual cases, and that generally takes time for any company to gather. So you have to find your good mediator with mass arb experience, and believe it or not, there aren't a ton in the U.S. yet, right? There's only maybe 10 or a handful that names keep popping up over and over. And then you need time to get the list and to vet them and determine whether they were customers or employees, or they do have claims, or they are alive, or all of those types of things before you then can enter negotiations. And so you can value the case for your client. And I think it's a good thing to do, because I've done it, I've had it both ways. I've fought them. I've had thousands of mass arbitrations that were in AAA and that we have had to fight. And it was a long couple-year war, and you're fighting in arbitration, you're fighting in federal court on certain issues. It's good for the defense firms to do that, but at the end of the day, I don't think it's good for the client. So I think you should take time, figure out if you can get to a good compromise. If you can't, there's a tolling agreement in place, as Jonathan said. If you can't, the claimants aren't prejudiced, and then you go to war. But I think it's in a client's best interest to figure out the lay of the land before they hit the button. I don't know, do you feel differently?
No. The only thing I'll add to that is, look, most of our clients, when they see a mass arbitration, they're seeing 10, 20,000 either employees or consumers who have nominally submitted a claim. And they actually want to do right by their customers, by their employees. And their initial reaction is, I don't want it out there that I have all these customers that think they have a claim. And so there's an incentive on their part to say, let's see if we can get a resolution if the other side is reasonable. And from our standpoint, that makes a lot of sense. And that's typically what our clients want us to do: engage early, see if we can reach a resolution. And there are some folks on this side that are not reasonable, and we've gone to war. And we've been quite successful in court in those circumstances. And others, typically we find that the other side is reasonable and will engage and will hear us and all of our concerns relating to campaigns or the claims.
And can you talk briefly about global release? I know we haven't, that's maybe a little bit in the weeds, but when we're talking about a firm that's facing both class and multiple mass arbs are there situations where you would advise a client to attempt some sort of global kind of settlement and release?
I mean, for me, yes. I think sometimes it takes, you have to get everybody in the room, the class counsel and the mass counsel, and get everybody in the room to talk. I think we're seeing in some cases with case law that's coming out that there are some firms that are trying to settle out, mass arbitration firms that are trying to settle out their population underneath the class counsel, and that's starting a war between the plaintiffs bar that's going on now. I think, and defense bar doesn't want to have any part of that war, so you have to be careful on how you're operating. But I do think one of the biggest questions is, okay, if we go into early mediation, but we only have these 5,000 individual claimants, but we have these other class actions out there, like, how does this work? How do we get peace? You know, how do we get peace? And that's where I'm going to say relationships matter, because sometimes, you know, I can tell you at this point, people that say, look, mass arbitration counsel that say, yes, here we go, we're not going to come back after, we have no present intention of coming back after your client, right? Because ethically, you can't say you're not going to sue the client again. But the ones that kind of we see right again, I'll never work with them again. Like, that's it. I'll never recommend to my client if you go back on your word. And we're trying to get this deal done. So I think you're trying to give your client peace. And it's important to get everybody in a room, but there's also times where you just deal with them one-on-one and hope they don't come back again.
All right, we're over our 5 minutes, but thank you all for being part of the panel today. Thank you, everyone.
Thank you.
Thank you.